The first question I always get from employers when I meet with them is this going to be repealed? And the answer is probably not. I met with a congressman from New York a few weeks ago, and that's one of the questions I asked him, and he said, no, probably not. We're probably going to make changes to it going forward, but the chances of repeal are nil. So please look at this. Now, will there be other changes to it? Will there be other delays? Probably. A couple things are real important to understand about this. And one of the more important changes in healthcare reform was the fact of new non-discrimination rules for insured plans. Those were supposed to be effective in 2011. The IRS came out with guidance in late 2010 saying it's going to be delayed until we come up with guidance. Well, we're going to go into 2015 and no guidance has been released yet. So the earliest possible that these non-discrimination rules are going to be effective is probably 2016 or 2017. And I think they're realizing the impact of these non-discrimination rules. So that's one aspect I'm not going to mention today, only because there's nothing to mention because no guidance has been released. Now, as Bill indicated, if you have any questions at all during the presentation, please let me know. More than glad to answer any questions, no matter how you think is elementary it is. It's going to be important. Just make sure it's on. Yes. It's extremely important because once you get lost in this, it's like a swamp. You're going to drown. So please, if something I've indicated either you don't agree with or you don't understand, please stop me because I can go on forever. I did a seminar a couple months ago for an accounting group on healthcare reform, and it was 8 hours. Now, this first presentation is going to be on what you should be worried about in 2014, 15, and 16. In the afternoon, I'll just be introducing this in the morning. In the afternoon, I will go through it in more detail. For 2015, there's going to be a new reporting requirement that every employer, 50 or more, if you're insured, will have to do. You have to tell your employees and then the government what full-time employees were offered coverage. That's starting in 2015, filed in 2016. Now, I want to warn you that this requirement is extremely complicated. The instructions are 12 pages. Now, in your packet of material, you'll see a series of forms, which I'll be covering this afternoon. These are just draft forms. The final versions have not come out yet. So what I'm going to be explaining is what we know now. These forms came out in late August, so they're fairly new. No, they came out in late July. The instructions came out in August. But I'll do the best I can to explain it. I'll do it generally, but the most important thing you get from this afternoon, one, it's extremely complicated. Two, you need help. And three, you'll probably get it wrong. Because it is extremely complicated. And therefore, if you complete it incorrectly and the IRS sends you a friendly letter, don't panic. Because of the fact you'll have a chance to defend yourself if the IRS tries to impose a penalty on you because you didn't check off a box. And I'll give you an example how this can happen. How many of you did any of you file the Form 720, the PCORI? Did anybody file one of those forms? All right, one of my clients, I didn't help them complete it, but on the form, you had to indicate for what quarter it was for, which doesn't really apply to PCORI fees, but you had to put in June 30th of whatever year it was. Well, they inadvertently put December 31st because that's what their plan year is, and they got penalized, even though they submitted the form correctly on time because they completed it incorrectly. So those are things that could happen, and many of this, when you get penalties, are going to be automatic. In other words, there won't be someone with the IRS that actually looks over it and everything. It's going to be spit out by a computer. So this morning we're going to be talking about what changes. I'll be talking about what changes apply to all employers, large employers, small employers, fully insured and self-insured employers. And let's look at the changes that apply to all employers. First of all, fees and taxes. The BCORI fee. The BCORI fee applies to every employer. If you're insured, the insurance company will pay it. It only applies to medical benefits. The fees were payable in connection with policy years after September 30th, 2012. It's going to continue into 2019. Now, if you're insured, don't worry about it. The insurance company will pay the fees, submit the forms, and they will charge you for those fees. If you're self-insured, then you have to file a Form 720. And the 720 is due July 31st of each year. So if your plan year ended in 2013, the PCORI fee would be due the following July 31st. All right? Now, the fee at first was $1 a head. It was for any plan years beginning after October 1st, 2012, and before October 1st, 2013. It went up to $2 a head, and that's something you should know about for plan years ending after October 1st, 2013. And it's determined on the average number of lives. The next fee is the reinsurance fee that's coming up, and it's due. You have to register by a certain date. This is for insured and self-insured programs, and the way to explain it to anyone is a slush fund for insurance companies. It was a way to attract insurance companies to the exchange. What the government's going to do is going to then collect this money and then use the money as a cushion for the insurance companies that were tempted to go on the exchange. So under ACE, each state is required to establish a transitional reinsurance program to help stabilize premiums for coverage in individual market. In other words, to entice insurance companies on the marketplace. The program is funded through reinsurance assessment on all health insurance carriers. The collected fee is used to support reinsurance payments to carriers that cover high-cost individuals. In other words, if the insurance companies lose a ton of money, the government is then going to give them a payment for participating on the exchanges. Now, for self-insured plans are ultimately liable for the reinsurance fee. Exempt self-insured, self-administered plans are going to be exempt for 2015 and 16. HSAs, health FSAs, expatriate health plans, and drug plans are excluded. And for fully insured plans, if you're fully insured, then don't worry about it, they will pay the fee. Now the fee is going to be, and you'll see this fee is going to be $63 a head for 2014. It goes on to $44 a head in 2015. Now for any of you that are self-insured, what you have to do, you have to go to a pay.gov website and register by November 15th. Because what you have to do, you're not going to get notice from CMS that the reinsurance fee is due. You have to actually go in, submit your information by November 15th, and then you'll see the first payment is going to be due in early 2015. So the first installment, the HHS will then notify each entity of the fee amount. Contributing entities will be notified in December, and payments will be due within 30 days. And the second installment will be due on the fourth quarter. The next fee is the health insurance industry fee. This is, again, paid by insurance companies. They will pass the cost on to you. It's going to be, first it's going to raise $8 billion, going up to $13.3 billion. And the fee applies to fully insured plans, including dental and vision plans, will be included in the fee. All right? But again, if you're self-insured, don't worry about it. You're not subject, so self-insured employers are not subject to the fee. At first, the fee is going to be between 2 to 2.5% of premium, as this slide shows, and it will be increased to 3 to 4%. So again, the insurance companies will pay the fee and then again pass the cost on to you, the employer. How is the fee determined? Each insurer's fee will be determined based on the respective market share of the premium amount. For example, the 2014 fee is based on the insurer's 2013 premium revenue. And the fee applies to most health insurance coverage, including dental and vision plans. And again, self-insured plans and other indemnity plans are not subject to the fee. But again, Don't worry about it. The insurance companies for insured plans will collect the fee. Now, another change was effective in 2014 is the 90-day waiting period. So for any plan years beginning in 2014, the maximum waiting period you can impose on an employee is 90 days. Now, please understand that 90-day waiting period only applies to full-time employees. If you have a business, and I'll be covering this in the next few minutes, and you have what's called variable hour employees, this 90-day waiting period doesn't apply. What is a variable hour employee? Is anyone who sometimes works part-time, sometimes works full-time. It could be a seasonal employee that works less than 6 months or less for you. For those individuals, which you can do, and I'll be covering this in a few minutes, you can do a measurement period of up to 12 months before they're eligible. Now, if you hire someone, it's extremely important to make sure that you categorize them in one of three buckets: full-time, part-time, and then variable hour. Here's your responsibility. Full-time, they have to be eligible after completing the waiting period. So whatever that is, 60, 90 days, they have to be offered coverage if they're full-time. And full-time is defined as working 30 hours or more or 130 hours per month. All right? Part-time. Part-time, that you know that that person will never work more than 28 or 29 hours a week. You have, under healthcare reform, you have no responsibility nor requirement to offer them coverage ever. All right? Thirdly, you have the next category, the third category, is variable hour. That person will, depending on the time of the year or the project, will work full-time. Other times they work part-time. And many types of industries have these type of employees. Restaurants, hotels, temp agencies, nursing homes have many variable hour employees, and in that situation, I'll be covering this in a few minutes, what you have to do is determine whether they're full-time, and you have to do it by the date in 2015 or 16 that you have to meet the employer mandate. You have to determine whether that person is full-time. That's going to be an extremely important determination, because what you can do, you can use any 3 to 12 month period to determine whether that person is full-time. All right? And many employers are going through that calculation as we speak. And some employer says, I only have two types of employees, full-time and variable hour, because we don't know when part-timers are going to work full-time. If somebody doesn't show up to a shift, part-timers come in and actually work more hours. In that situation, then if you're not sure part-timers will never work more than 30 hours, I would measure them. And over a 12-month period, in order to be full-time and offered coverage, they have to work 1,560 hours. So it's 130 hours per month times 12 is 1,560 hours. Okay? Any questions so far? Now let's go back to the 90-day waiting period. The 90-day waiting period indicates that this is a period of time that person can wait to be eligible. And what's important here, and it only applies, this is trying to say it only applies to medical. If you want, you can do a longer period of time for dental, vision, or any other benefits that you offer. This 90-day waiting period only applies to medical. Please understand that. Now, one thing that's very important, and this was in the February 2014 regulations, the IRS said, oh, by the way, you, Mr. Employer, can impose a 30-day orientation period before you start the waiting period. And we went, what? You're telling us now? After the rules are effective? So as an employer, what you could do is not only have a 90-day waiting period, but you could have a 30-day orientation period before you actually start the waiting period. All right? if you wanted to. And they gave no other guidance on this. None. So what I'm suggesting to my clients, if you're going to put this 30-day orientation period on it, you should basically put that in your handbook, in your SPD for your medical plans, that I'm sorry, but before you actually start, you have to do a 30-day orientation period before you actually can start the waiting period. So the employers may be subject to a penalty, and the longest period a full-time person can wait to be offered coverage is the first day of the fourth full calendar month of employment. And this example shows this. If you hire somebody on January 6th, what's the latest you can offer? And let's say that person is full-time. The longest period of time they can wait is May 1st. And that's what the government's saying. So therefore, it's going to be longer than 90 days, but not exactly 120 days. So that's the longest period you can withhold coverage when somebody is full-time. Now, the most important thing you have to do is understand you have to categorize your employees for employer mandate purposes: full-time, part-time, and variable hour. A waiting period is a period of which must pass before coverage if an employee is dependent or dependent would otherwise be eligible. Some union plans have 1,200 hours. That's to include part-time employees, but you basically, for this purpose, you count all days. Now, one of the misconceptions you have, suppose you're an employer, and last year, 2013, you had a 6-month waiting period. And your 2014 plan year starts. What happens to those employees that had a 6-month waiting period? It's gone. That 90-day period applies to all employees beginning in your 2014 year. So if you had a 6-month period in 2013, as soon as the 2014 plan rolls in, if they've completed 90 days, they have to be eligible the first day of the plan year. That's the most important question I've been getting. Well, aren't they grandfathered? No. It applies to all employees, so please remember that. Pre-existing condition, of course, everybody knows this, are no longer applicable. And the only reason why that's here is for this. Make sure if you look at your documentation that you have for your benefits, your handbooks, your summary plan descriptions, make sure that any reference to pre-existing conditions are taken out for the starting in 2014. And there's various provisions in your handbooks, in your SPDs, talking about a pre-existing condition exclusion. Please make sure, starting in 2014, nobody can impose a pre-existing condition exclusion. So make sure it's out of there. Secondly, when you impose a pre-existing condition exclusion, you had to get a certificate of credible coverage. So if that person left their employment, they had something in their hand in case somebody wanted to impose it. And the question is, well, since it doesn't apply to us anymore, do we have to give out that certificate of credible coverage? And the answer is, I would continue to give it out until the end of the 2014 calendar year. Because there could be some employers with an October, November, or December plan year that until then they can impose that pre-existing condition. All right? So I would give out that certificate of credible coverage until December 31st of 2014. And this talks about, again, the pre-existing, it's for plan years beginning on or after January 1st, 2014. Out-of-pocket limits, remember for the first time, the government has imposed an out-of-pocket limit that includes deductibles, co-pays, co-insurance. That's effective for 2014. Now, what's interesting about this, the limit was $6,350 for single coverage and $12,700 for family coverage. The limits for 2015 were announced. It's going to be $6,600 for individual coverage and $13,200 for family coverage. Now, please understand that limit is different than the limit for HSAs. If you're eligible for an HSA, the limit is 6450 and 12.9. So there's one limit for ACA, and there's another limit to be a high deductible plan for HSAs. And if you have a limit that high, for example, you would not be eligible for a HSA contribution, to make an HSA contribution. So the limits are different starting in 2015. And again, this limit does not apply to grandfathered plans. Wellness programs. Wellness programs are becoming very popular. Many employers are instituting them. A side note, EEOC is starting to get involved with wellness programs. There is a suit, I think, in Wisconsin where the EEOC is suing an employer. And this employer said, well, if you don't take the wellness program, not all the plans that we offer to the employees are going to be available to you. And the EEOC actually sued the employer and saying, no, that's discrimination and it violates the ADA, Americans with Disabilities Act. And let's see where it goes. Because so far, over these many years, the EEOC has not said a peep officially in regard to wellness programs. Now, wellness programs, what you can do, if somebody participates in a wellness program, the benefit of participating can be a reduction of up to 30% of the premium for that employee. Now, there's two types of wellness programs: participation-based, where basically you just show up to a meeting, as opposed to outcomes-based, where you actually have to lose weight and lower your cholesterol. These limits only apply to outcome-based programs, 30%, and the total cost of coverage is the premium. For smoking cessation programs, it can be as high as 50%. So you can reduce or impose a penalty on an employee for not participating under the wellness program. Cafeteria plans and HRAs. They've been severely affected by ACA. And first of all, Notice 2013-54 prohibits reimbursement of premiums for individual policies from health reimbursement arrangements and premium-only plans, which is a form of a cafeteria plan. What some employers were doing, they were getting rid of their group health plans and saying to the employees, we're going to help you with that payment. We're going to give you so much per year, and you show us evidence of you have individual coverages, and we're going to reimburse you. Either we'll give you money through a health reimbursement arrangement, or you can actually pay for those individual premiums through a cafeteria plan. And the government said, for medical plans, you can't do it. So no longer can an employer reimburse an employee on a pre-tax basis for individual medical policies. It's no longer possible to do so. Now, premiums can be, individual premiums still can be reimbursed for dental, vision, various individual coverages like AFLAC, still possible. But anything dealing with medical programs, you can't be done. So please remember that. There are still vendors pushing this, but I've personally talked to the DOL, and they said, nope, we're not going to allow it anymore. So again, if you want to do this, and you want to reimburse individual premiums, basically what the guidance indicates, it's going to be post-tax, and it's going to be not dependent on actually getting insurance, which means an old-fashioned bonus, and not conditioned on actually getting insurance at all. Also, too, what some employers were doing, if they couldn't afford a group coverage, they were actually putting in what we call freestanding HRAs, giving employees so much per year, saying, we'll give you $5,000, and you present us evidence of either expenses or premiums, we'll reimburse you. This notice, 2013-54, said, nope, no longer can you have for medical expenses what's called a freestanding HRA. It's going to be integrated with the group health plans, and it's going to be integrated, and what's could be reimbursable dependent if the health plan provides minimum value. You can still do a freestanding HRA to reimburse dental and vision plans, but you can't do medical any longer. All right? Any questions so far? Health FSAs. If anybody sponsors a health FSA, certain health FSAs are not subject to health care reform. Those are considered to be an exempted benefit. And you can still have a freestanding health FSA. In other words, you waive employer coverage. You can still participate in the health FSA, but it's got to reimburse only dental and vision plans. Now, what requirements apply if a health FSA is not an accepted benefit? Well, in that situation, one, the employer contribution cannot exceed $500, and two, the plan has to be offered with a group health plan. Next, another change is for health. If anybody sponsors a health FSA, which you can do, you can allow an employee to carry over up to $500 to the next year. And the reason why many employees didn't participate under health FSAs is because they would lose money if they guessed wrong. Well, all of a sudden the IRS said, well, because the limits under health FSAs are limited now to $2,500, we're going to allow, and Mr. Employer, you could amend your plan to actually allow employees to carry over up to $500 into the next year or forever until it's used up. All right? Now, carryovers can be allowed to be used for all the next year. So again, until it's used up, it just stays there. But there's still many unanswered questions. We don't know, for example, if that carryover amount, if that person terminates, whether that carryover amount actually, would you have to put in a COBRA premium for that carryover amount? We don't know yet. The IRS hasn't addressed this. But please remember that you don't have to do this if you don't want to. In order to allow this, the cafeteria plan must be amended to allow it. Some employers are doing it, but it's not required. That's what I'm trying to say. Defense of Marriage Act, DOMA. In Illinois, it's a fait accompli. But again, the guidance from the service says you may recognize same-sex spouses but not required. This was a hot issue in all the states around us that didn't had laws against same-sex marriage. Indiana, Michigan, Wisconsin. But what I was telling, even though the federal law does not require recognition of same-sex marriage, what I was afraid of, and it's happening, is this statement right here. If you don't recognize same-sex marriage, it may be a violation of other federal rules. And that's why these statutes around the country are being repealed, because with these various federal courts are realizing that the same-sex marriage violates the equal protection law. And when I'm advising my clients across the country, I'm sorry. Either recognize same-sex marriage, offer them coverage, or drop spousal coverage entirely. Those are your two choices right now. And especially in Illinois, but if you have locations in other states, and we're hoping, because those states had, again, bans against same-sex marriage, I think within a year or two, all of them are going to be lifted. And remember, under health care reform, you're not required to offer coverage to the spouse. And some employers, what they're doing, they're dropping spousal coverage, and this is one of the reasons. All right, so that's your out in that regard. Now, one thing I'm also warning, if you do recognize same-sex marriage, and you're asking same-sex couples to produce a marriage license, please do the same thing for opposite-sex couples. Make it uniform for all employees. If you're going to cover your spouse, I'm sorry, but you have to give us evidence of the marriage, and the marriage license is the best evidence of a marriage. So if an employer decides to offer same-sex marriage, make any necessary amendments to the definition of spouse, confirm with the third-party administrator providers updating policies and procedures, Make sure insurance policies are consistent with your decisions. Determine how same-sex spouses will be identified. And ensure that payroll systems are updated to reflect proper tax treatment. So again, there could be still some state tax issues that still have to be recognized, especially in those states that don't recognize same-sex marriage. All right, any questions so far? Anything I've talked about so far? Nothing? Come on. Yes?
On the health FSAs, if that $500 can be carried over later, is that cumulative then, or do you still have a $2,500 limit?
It doesn't affect the $2,500 limit. It's considered technically as an employer contribution. So again, in that situation, that person could carry it over for years if they wanted to. So it's up to the employee when they use it. But again, the issue and problem with that $2,500, that $500 carryover, is the fact if that person, for example, decided to participate in their health in a health savings account, they would prohibit them from actually being eligible because they have that $500 still sitting there. So when I'm advising, and the IRS has agreed on this, what you can do, you can give an employee an option how that money is carried over. Either a general purpose where it recognizes all medical expenses or only dental and vision. So that would make that person eligible to participate under an HSA. All right? Any other questions? All right, let's move on to large employers. And under the Health Care Act, a large employer has been defined as any employer with 50 or more full-time equivalent employees. That determination is made in 2014 to see how many employees you have. And so whether you're subject to the mandate in 2015, all calculations are done in 2014. Now, the way it's done is, and this confuses a lot of people, the definition of full-timer for this purpose is anyone who works 120 hours or more per month. But Larry, you said 130 hours just a few minutes ago. Well, for this purpose, a full-timer is 120 hours. So one employee, if they work 120 hours or more, that's one full-time employee. Anybody that works less than 120 hours, you total up their hours for the month, and then divide by 120, and that gives you what's called a full-time equivalent employee. All right, you add the two figures together for each month, then you add the 12-month figures, divide by 12, and that figure in 2015 is 100 or more, then you're subject to the mandate in 2015. So those between 50 to 99 have a reprieve, and I'll be talking about what hoops you have to jump through in 2015. But again, for 2015, the mandate only applies to those employers with 100 or more full-time employees, and that is defined in 2014. Now, what they've done, what the government has done also, is they've given you a transition rule that said, Mr. Employer, even though the statute says 12 months, we're going to give you a deal in 2014. And you can make that large employer calculation for any consecutive 6-month period in 2014. And I've used this a couple times with different companies who at various months during the year have very few employees that got them out of the mandate for 2015 because we used the 6-month period where they didn't have that many employees. So again, 100 or more in 2015 is determined during 2014. Now let's look at the employer mandate. So beginning in 2015, certain large employers may be subject to penalty taxes for failing to offer health coverage to full-time employees or offering minimum essential coverage that's not minimum value or affordable, which I'll be covering in a few minutes. Okay? And the penalty tax is due if any full-time employee is certified to the employer as having purchased health insurance through the exchange. Now, this is one of many transitional rules. Now, the mandate says that you're going to be subject to the mandate by January 2015. So if you're 100 or more, but they give you a reprieve, and there's a transition rule, which is explained on the slide. And let me explain it. It says that, okay, if you have a date, if you have a plan year other than January, and suppose your renewal date is April, May, June, July, August, September. So you can use that September date, your renewal date, if you have to jump through some hoops. And the first hoop is right here, as we look at any date within 12 months of February 9th, 2014, did you offer coverage to at least 1/3 of all your employees or 1/2 of your full-time employees of any date prior to February 9th, within 12 months of February 9th, 2014, or did you cover at least 1/4 of all employees or 1/3 of your full-time employees? If you met one of these two rules, then the mandate is not applicable as of January, but your renewal date in 2015. Now, in layman's language, what am I trying to say? If you're an employer in the past that offered coverage to most of your employees, and doesn't matter who took it, but you offered to most of your employees, and your renewal date is October 2015, that's when you have to comply. If you're an employer that you have a lot of people working for you, but you didn't offer it to that many people, you only offered it to your managers, and you have 100 or more employees, then what you must do is then comply as of January 1st, 2015. That's what that is trying to say. All right? So the last safe harbors will be available to employees who have offered coverage minimum value starts in 2015. But again, in most cases, an employer could determine the percentage of covered employees as of the end of the most recent enrollment date before February 9, 2014. Now, who is a large employer? Again, as I indicated before, that determination is made in 2014 and is done on a control group basis. I don't know how many control group charts I've looked at over the last year. But again, basically what a control group is, does your employer own and do the same 5 or fewer individuals own 80% of each entity? Those are the control group rules that you see on Code Section 414B, C, and M. If they do, and if your employer owns other businesses, for the purpose of the employer mandate, that's considered to be one employer. One. And that determination is made accordingly. So as I indicated before, in determining the number of full-time employees, an employer must add up the total number of hours worked in a month by part-time employees and divide by 120 hours. So for this purpose, a full-time employee is anyone who works 120 hours or more. That's 120 hours, and all added up for the part-timers, you divide by 120, that gives you what's called a full-time equivalent employee. The two figures are added together for each month, and then we look at the end of the year, December 31st, 2014, to see if you're large or not. All right? Now, if you're between 50 to 99, you have a reprieve. The reprieve is you can wait till your renewal date in 2016, but you have to jump through a couple of hoops. One, you have to have between 50 to 99 employees. You have to maintain your workforce and not get rid of people because of Obamacare, have a business reason. Get rid of people. And I have some employers have actually admitted, we told people we're getting rid of them because of Obamacare. Not a smart move. And then if you were maintaining health coverage, you had to not drop your coverage, not change it, and not change the plan year. All right, so you have to maintain previously offered health coverage. And then lastly, you have to certify to the IRS that you comply with these rules. The certification form has not been released. And I would imagine you probably have to attach it to your business return, probably sometime in 2015. All right? Any questions so far? Yes, sir.
Larry, you just mentioned and not change the plan year. Does that mean that if I had a plan effective date of April 1st, but I moved that plan year to December 1st, that I changed the plan year and now I'm outside?
Now that change had to be done. That change had to be done after February 9, 2014.
Okay.
So if you changed it after the date, you are correct. You would blow the exemption. You have to comply as of 2015. Or if you got rid of your plan, all of a sudden you're subject to the mandate in 2015. Okay? Now, there's a special rule in the statute that says if to determine with your large employer, if you employ seasonal workers, let's say in this area you own 4 Dairy Queens, and generally during the year you employ 30 people. You own 3 or 4 or 5 Dairy Queens, but during the summer you employ hundreds of people work for you. And if you had to add them in the total, it could get you over 100 or over 50. And the government says if you have seasonal workers that work 120 days or less, they can be ignored for the large employer calculation. So again, if you or any of your employers or a client has a lot of seasonal employees, that could make them ineligible and not be a large employer. So penalty taxes. One tax applies if you don't offer coverage, and the second tax applies if your coverage is either not affordable or not minimum value. And minimum value is considered to be 60%. Now, most employer coverages in existence right now are way beyond that 60% figure. And what I'm advising most of my employers is that look to offer a cheaper plan in either 2015 or 2016 when you have to comply with the mandate. Because what you're offering right now generally, and there are exceptions, are much richer than what you have to offer in 2015 or 2016.